The citation notice was sitting on our kitchen counter when I arrived home from work, red ink shouting from the official HOA letterhead, "Aesthetic infraction, obtrusive mobility devices visible from public view." Karen Whitlock had no idea she'd just picked a fight with the wrong family. My brother Jake is a disabled vet, and my sister Ellie is a civil rights attorney specializing in ADA law. She's about to turn Karen's world upside down. My name is David Ellison, and I work as a school counselor at Red Maple Elementary. My brother Jake used to work in home construction before an accident on site left him paralyzed from the waist down 3 years ago. We live in Red Maple Commons, a polished suburban enclave where every mailbox is the same black wrought iron and decorative items are strictly prohibited. Jake had just completed installing his new handcrafted wheelchair ramp and switched to a powered chair with medical attachments that were visible. The ramp looked amazing. Stained wood that blended seamlessly with the house, and safety-grade railings he designed himself. After months of getting by with a temporary metal ramp, Jake was proud to finally have a solid and elegant solution. But Karen Whitlock, who presides over our HOA, didn't see it that way. The notice was thorough and demeaning. Permanent ramp construction violates established aesthetic rules. Power chair with attached medical components creates an unpleasant view when left in driveway. Immediate resolution required or daily penalties will apply. Jake wheeled into the kitchen as I read it, his face falling the moment he saw my expression. "What's wrong, David? You look like you've just heard terrible news." I gave him the letter. His jaw set hard as he scanned the words, his grip tightening until his knuckles went pale. "Unpleasant mobility devices," he whispered, his voice shaking. "Is that what I am now? Just some ugly appliance ruining their perfect street? Jake, this is absurd. That ramp follows all code requirements and your chair is necessary medical gear. It won't make a difference. I knew this was coming. I should have kept using the back door like a delivery guy. No way. You deserve to use the front entrance like anyone else. This is plain and simple discrimination." Jake's eyes brimmed with tears. He tried to blink away. "Maybe they're right, David. Maybe I do make things look worse. Maybe we should move somewhere more suitable. Don't let them shame you. You served this country. You have every right to live with pride. Read what it says, David. They want me to tuck away my wheelchair. They want me to pretend I'm not disabled so their property values stay intact. Well, they can shove their property values. You're not hiding anything. But what if the other neighbors agree with her? What if I really am dragging the area down? Then they're all wrong. Every last one of them." Jake rolled toward the window and looked out at the ramp. "I spent 3 weeks on that thing. I checked every regulation, every ADA clause. I made it match the house, and they call it hideous. It's not. It's impressive, practical, and it's yours. I just wanted to feel human again, David, to walk through the front door like a normal person. You are. And that's the door you'll keep using." But the next day, it got worse. Karen had posted a copy of the citation on the neighborhood bulletin board near the clubhouse, aggressively marked in red around obtrusive mobility devices and aesthetic infraction. Our street address was plainly visible for all to see. Residents walking past could read our public shaming, just for Jake being disabled. Mrs. Patterson from next door gave me a sympathetic glance but said nothing. Tom Bradley across the street stopped to read and shook his head with disappointment. Fuming, I drove straight to Karen's place. She opened the door with her rehearsed smile, silver hair perfectly styled, HOA badge gleaming on her blazer. "David, what a surprise. What brings you here on this lovely morning?" "Karen, we need to discuss the violation notice you posted in public view." "Oh, the ramp issue. I was hoping we could settle that quietly without lawyers or unnecessary escalation." "Settle what, exactly? My brother's right to get into his home?" Her tone turned patronizing. "There are more subtle ways to manage these matters that don't compromise the community's appearance. Perhaps a less noticeable solution would be better. He spent years building homes here before his accident. He literally helped construct this neighborhood." Karen's smile stayed in place, but her eyes turned cold. "I know emotions are running high, David, but Jake's setup affects the visual appeal of the area. This is a residential zone, not a rehab center. This is his home, ours, not a clinic. And it should resemble a home in Red Maple Commons, not a facility. Home values impact everyone, not just your household. He's disabled. That ramp and chair let him live independently. I'm sure there are more discreet options. Maybe move the ramp around back where it's out of sight. Or use a temporary structure. You're suggesting he should hide his disability to keep you comfortable? This isn't about feelings, David. It's about upholding the community rules that protect property value. We all agreed to those terms. Community covenants don't trump federal disability law. For a second, her facade cracked. Federal guidelines don't force us to turn our streets into showcases for hospital gear. There are neighborhoods made for people with Jake's needs. Needs? You're talking about my brother like he's faulty equipment. I'm discussing the upkeep of property worth for hundreds of families depending on this neighborhood maintaining the right image. Image? What's wrong with a disabled veteran having safe access to his own house? The devices, David. The visibility of medical aids. The way they alter the original architecture. These factors matter in communities like ours. And those outweigh my brother's basic dignity? They matter to families counting on home equity for college tuition, to retirees relying on property value for financial security. And my brother's rights matter to the federal government. Karen's tone turned harsh and venomous. Civil rights don't entitle you to destroy the investments of others, David. Civil rights ensure my brother can enter his home without concealing his disability. And the HOA agreements allow me to uphold rules that protect the broader community. We'll see about that. That evening I called my sister Ellie. She's a civil rights lawyer focused on ADA enforcement, and she doesn't let injustice slide. Ever. They did what? Ellie's voice turned ice cold as I explained. They posted our citation where everyone could see it, labeled Jake's ramp and wheelchair as unsightly. Even said we should move somewhere meant for people with his limitations. Did they actually put that discriminatory language in writing? It's all in black and white. She wrote down every word, including calling his mobility aids unsightly devices. Good. That's shockingly ignorant, but excellent for the case. David, this woman just handed us a federal discrimination suit gift-wrapped. I just want Jake left in peace. He deserves to live with respect. He will. But first, I'm going to make sure they realize what they've done. I'm going to burn down Karen's petty little empire. I just need this to end. And it will. Once I'm through with Karen Whitlock, she'll think twice before harassing another disabled person. That's my word. What are you planning? I'm thinking Karen has no clue what happens when ADA law is enforced properly. She's about to receive the most expensive lesson of her life. How expensive? Low 6 figures at least. Could even push 7. Add legal fees, add injunctive orders, add federal oversight, and possible criminal referrals if we find proof of coordinated action. Criminal charges? David, this goes beyond a civil violation. This is a deliberate plan to pressure disabled people to leave. That's housing discrimination, and it carries criminal consequences. I didn't realize it was that serious. Karen has no idea either. She assumes she's targeting someone powerless. What she doesn't know is she's going up against an ADA litigator with a flawless track record. 3 days later, Jake got a new letter, this one even more severe. Final notice. You must comply within 72 hours or face $100 daily fines. Community standards are for the collective good of all homeowners. Jake stared at the paper, and the quiet resignation on his face crushed me. Maybe I should just park my wheelchair in the garage and go in through the back. Absolutely not. You're not going to hide medical equipment because Karen finds it offensive. But emotionally, he was already withdrawing. The shame from being publicly called out had clearly reopened old wounds I hadn't seen since right after his accident. David, I don't want to be that neighbor, the one people blame for lowering the neighborhood's image. You're not the issue here. She is, and you are not a blight. But the whole block saw that notice. Now everyone sees me as the guy dragging down their property values. Jake, listen to me. I knelt beside him. You are not broken. You are not ugly. You're not a burden. You're my brother, and you have every right to feel proud and live with respect in your home. Jake's voice wavered. Sometimes I wonder if Karen's right. Maybe I never should have left the rehab facility. Maybe I don't belong in a place like this. Don't ever say that again. This is where you belong. We belong here, and I'll make sure everyone knows that. But what if she's right about home values? What if the ramp really does ruin how the neighborhood looks? Jake, that ramp is incredible. You designed and built it yourself. It matches the house. It's 100% compliant with the code. And it lets you live your life independently. But it's still medical gear, right out where everyone can see it. So what? You're a person who needs accessibility tools to live. That's not embarrassing, it's just the truth. Truth that Karen wants out of sight. Karen's opinion is irrelevant. The law is what matters. Your dignity is what matters. Your right to enter your home is what matters. I'm just exhausted, David. Since the accident, it's been a constant fight. Learning to function again, coming to terms with the wheelchair, trying to feel whole. And now I have to fight just to exist in my own neighborhood? You're not in this alone. Ellie's stepping in now. Ellie can't change the fact that I make people uncomfortable. You're not the problem. Their ignorance is. That discomfort is theirs to deal with, not yours to fix. I filed an official complaint with the HOA board, asking them to evaluate Karen's actions and cancel the violation. But instead of backing down, Karen doubled down. She came to our property in person, camera in hand, snapping photos as Jake transferred from his chair into his modified van. "What the hell are you doing?" I demanded, stepping protectively between her and my brother. "Recording potential safety risks. That ramp obstructs emergency vehicles from accessing your driveway. It's 3 feet wide. An ambulance could drive through it sideways. That's not my call. I'm gathering evidence for the HOA's insurance team about possible liabilities." Jake looked deeply embarrassed as she continued taking pictures. "Karen, please stop. This is humiliating." "I'm sorry, Jake, but this is necessary for the community's safety documentation. Our job is to protect every resident." "You're not protecting anyone. You're targeting a disabled veteran." Karen's tone sharpened. "I'm safeguarding this neighborhood from becoming a haven for anyone who thinks disability gives them a pass to break rules." Break rules? Jake followed every ADA requirement. He didn't get HOA approval. That ramp violates our design protocols. He ignored our guidelines because he needs it just to get into the house. Need doesn't excuse bypassing proper application procedures. Every homeowner follows them. None of those homeowners rely on wheelchairs, and none of them expect special exceptions due to personal conditions. Jake spoke from his wheelchair, his tone low but unwavering. "Karen, I'm not asking for special privileges. I just want to live in my home with dignity." Dignity doesn't require breaking community rules, Jake. Neighborhood rules shouldn't force me to conceal my disability. They don't force you to hide anything. They just ask everyone to follow the same application process. You mean the process that takes 3 months while I can't use my front entrance? The process that keeps our neighborhood consistent and beneficial for all. My benefit would be having access to my house. And the benefit of the community is maintaining the right visual standards. Visual standards that exclude disabled people? Visual standards that preserve property values for everyone here. The next HOA meeting was packed to capacity. Karen had clearly spread the word about the issue regarding Jake's ramp. I sat quietly in the back row while Jake stayed home, unwilling to endure more staring or whispered judgments. The ramp at 1247 Maple Court presents ongoing visual and safety concerns, Karen told the gathering of 30 homeowners. This isn't about prejudice. It's about upholding the rules that keep all our properties valuable. Mrs. C. Henderson raised her hand. "But Jake is disabled, right? Doesn't he need that ramp to get into his house?" Mr. Ellison's personal condition doesn't cancel out the neighborhood agreements we all accepted. There are suitable ways to manage accessibility without impacting appearance. "But where else could a ramp even go?" Mr. Chen asked. "The back of the house would be a better location for storing medical-related equipment. Many developments have policies like that." Mrs. Patterson joined in. "That feels harsh. The man served in the military." "His service is commendable," Karen replied, "but it doesn't exempt him from following the rules. If we begin making allowances based on individual stories, where do we stop?" Tom Bradley raised his hand. "When my mom was in a wheelchair, would her ramp have violated the rules too?" Any permanent structural change requires review by the architectural committee, regardless of circumstances. "But you're clearly singling out Jake." "I'm enforcing the..." Same guidelines across the board. The Ellisons made unauthorized changes without following the procedures. He needed it just to enter his home. Needing something doesn't mean the process can be ignored. We have these rules for a reason. Just then, my sister Ellie entered the room. She had recently moved from Washington, D.C., purchasing a condo in Red Maple Commons to be closer after Jake's injury. Karen didn't recognize her yet. "I'd like to comment on this matter," Ellie said evenly, standing at the back. "Are you a homeowner in Red Maple Commons?" Karen asked. "Unit 47B, Maple Court. I moved in last month." "Welcome, then. What would you like to share regarding the ramp?" "I'd like to hear the legal justification for violating federal disability protections." Karen's smile faltered just a bit. "We're not breaking any laws. We're simply enforcing fair community regulations that apply to all. Community rules don't take precedence over the Americans with Disabilities Act." "I've dealt with people like you before," Karen replied curtly, her voice taking on a sour tone. "Newcomers who toss around legal jargon to get special privileges and exceptions to rules." "My type? People who use legal language they don't understand to pressure volunteer board members trying to preserve property value." Ellie gave a calm but razor-sharp smile, the one I'd seen her use during depositions when the opposing attorney made a fatal mistake. "Actually, I'm very familiar with the law. I'm a civil rights lawyer and I specialize in ADA cases." The room fell completely silent. Karen turned visibly pale. "For the record," Ellie went on, "everything said here today can be considered evidence of deliberate discrimination against someone with a disability. The ADA mandates reasonable accommodations for housing, and ramps are one of the most basic forms of accommodation." She held up a thick folder. "I've reviewed several similar cases in this jurisdiction. Discrimination involving mobility equipment in housing typically leads to damages between $50,000 and $200,000, plus legal fees, which often exceed the damages." The board members looked alarmed. Karen stood her ground, though clearly rattled. "Is that a legal threat against this board? I'm citing federal law. But if you want a warning, here's one. If Jake receives even one more citation over his medical gear, I will file a federal lawsuit that will make your HOA the centerpiece of a national disability discrimination case. You can't bully us with legal threats." "I'm not bullying anyone. I'm telling you plainly, if you break federal law again, you'll face the full legal consequences. And believe me, Mrs. Whitlock, you do not want to know what that looks like." "We'll see about that." "Yes, we will. I've represented clients in 47 ADA discrimination cases, Mrs. Whitlock. I've never lost. The average result? $180,000 settlements, attorney's fees, policy reform, and long-term federal monitoring. This isn't discrimination, it's enforcing community regulations. Regulations that single out disability-related modifications while allowing purely decorative changes for able-bodied residents? That's textbook discrimination under federal housing law. We approve changes that follow the design standards. Design standards that systematically reject accommodations for disabled residents are illegal under the Fair Housing Act. We don't reject anything across the board." "Mrs. Whitlock, you publicly called wheelchair ramps unsightly and told a disabled veteran to move to a community more suitable to his condition. That's not policy enforcement, it's active discrimination." The room stayed deathly quiet. Several board members exchanged worried glances and whispered. "And another thing," Ellie added, "posting violation notices that specifically target medical equipment in public view constitutes both harassment and retaliatory behavior under federal statutes. That alone could be worth $25,000 to $50,000 in damages. Now you're definitely threatening us." "No, I'm informing you about the law, Mrs. Whitlock. The threats will come later, when we're in federal court and the Department of Justice steps in." "The DOJ?" Karen echoed, her voice tight. "Federal housing discrimination cases often end up with the Department of Justice," Ellie said. "Coordinated efforts to exclude protected groups can lead to criminal indictments." Karen's composed expression was starting to falter. "You're just trying to scare volunteer board members." "I'm trying to stop you from committing federal offenses. Think of it as a civic intervention." After the meeting ended, Mr. Bennett, an older board member with gentle eyes, approached me quietly in the parking lot. "Mrs. Ellison," he said in a hushed voice, I have something for you, but not out here where anyone can see. He handed me a small flash drive. I've been recording board meetings for years. I had concerns about Karen's actions. There's information on here you need to hear, about your brother. What kind of information? The kind that will make winning your case almost effortless. Karen's been orchestrating this campaign against your family for quite some time. She planned this? She's been crafting a strategy to push you out without it looking like discrimination. Every step is documented, her intentions, her plans, her methods. Why give this to us now? Because it's wrong. I've been on this board for over a decade and a half, and I've never seen anyone treat disabled residents the way she does. There have been others. 3 families over the past couple of years. All of them chose to leave instead of fighting. Karen follows a pattern. That night, Ellie and I sat at the kitchen table, headphones in, going through hours of audio from Bennett's flash drive. What we heard made our stomachs turn. Karen's voice echoed from one meeting. The Ellison problem is exactly what I've warned about for years. First, it's wheelchairs and ramps. Next thing you know, hospital beds out front and oxygen machines cluttering driveways. Board member Thompson chimed in. But Karen, he's disabled. Doesn't he have legal protection? Karen replied coldly. His rights stop where our property values begin. Jake Ellison is a disgrace. His equipment makes the block look like a nursing home. We need to shut this down before more disabled people get ideas. From a meeting 2 weeks earlier, we have to make this situation so uncomfortable and financially draining that they move on their own to someplace better suited to their condition. Board member Williams said, "That sounds like harassment." Karen answered, "It's tactical enforcement. There's a difference. We log every violation and let them draw their own conclusions about whether they belong." The most incriminating clip featured Karen laying out her full strategy. The trick is to make life so unbearable that these people remove themselves. Legally, we can't block them from living here, but we can sure make them regret it. Thompson asked, "How do we avoid getting sued?" Cite them for every small infraction. Hit them with daily penalties. Post violations where neighbors can see them. Raise safety flags. Stir community tension on social media and at meetings. What if they get a lawyer? Most won't. Disabled families are already overwhelmed. Medical bills, stress, everything. They usually leave rather than take on a lawsuit. And if they don't leave, we keep pushing. I've gotten rid of 3 families using this model. It's effective. Ellie's stare was ice as we listened. She's not just violating rights. This is a coordinated conspiracy. We're in civil rights prosecution territory now. The recordings continued, Karen openly scheming how to push us out. Hit them with daily fines. That's usually enough. Most can't afford a prolonged fight, especially when they're dealing with health expenses. Thompson's voice came again, nervous this time. What if they hire an attorney? Most ADA lawyers work on contingency. They won't take a case that's not a slam dunk. We just keep our infractions detailed enough to cause doubt. One of the worst clips was Karen revealing her big picture vision. The point is demographic control. We're not letting Red Maple Commons become an assisted living suburb. Property value depends on the right kind of residents. Then came the clip that removed all doubt. I'm not running a shelter for cripples. This is a top-tier community, and we're going to keep it that way. Williams protested, Karen, you can't say that. I'll say what I want in private meetings. The goal is to protect the neighborhood's image and value. But specifically going after disabled residents, I'm not targeting anyone. I'm applying the rules in a way that excludes the wrong people. Ellie hit pause, her jaw tense. She doesn't know what she's unleashed. This isn't just a lawsuit, it's a potential RICO case. RICO? I asked. Racketeer Influenced and Corrupt Organizations Act. Basically, organized illegal behavior. Karen's constant fines and inflated compliance penalties amount to extortion under federal law. This is more serious than I imagined. It's massive. Karen Whitlock has built an entire system around denying civil rights and recorded the whole thing. Then came her fatal mistake. The next morning, she pushed through an emergency board vote authorizing the immediate removal of Jake's ramp. The excuse? New emergency access code violations. We got the official letter by certified mail. Urgent compliance order. The ramp must be dismantled within 48 hours due to critical safety violations. Failure to comply will result in HOA-directed removal at the homeowner's cost, estimated $2,500. Jake read the notice, tears rolling down his face. They're actually going to rip it out. They're taking away the one thing that helps me feel like myself. No, I said, voice steady. They're not. David, maybe we should just let it go. Maybe I should be somewhere I don't cause problems. Look at me, Jake. You're not going anywhere. This is our house, and we're not backing down. But what if they're right? What if I really am hurting the neighborhood's image? They're not right. They're criminals, and they're about to face federal justice. Criminal justice? Ellie's found proof that Karen's been actively targeting disabled residents for years. This isn't just bias, it's a criminal operation. I don't want to be dragged into a criminal investigation. You're already in this, Jake, I told him gently. Karen dragged you into it the moment she made our family her target. I just want to live in peace, he whispered, and you will. Right after we make sure Karen Whitlock can never harm another disabled family again. That's when Ellie officially filed her federal lawsuit. The complaint was brutal. 47 pages packed with accusations of ongoing disability discrimination, civil rights violations, emotional abuse, and racketeering under the RICO statute. Ellie demanded emergency court-ordered protection, reimbursement for damages, punitive penalties, triple damages under RICO, and full legal expenses. She didn't stop there. She also submitted a formal criminal report to the Department of Justice and reached out to Maya Grant, a well-known journalist who specialized in civil rights for the Washington Post. Maya was immediately captivated by the story of a disabled veteran being harassed by his own homeowners association. This is exactly the sort of systemic abuse the public needs to know about, she told me during our call. Would Jake be open to speaking with me? He's overwhelmed from the attention. I'm not sure he wants to be in the spotlight. Sometimes transparency is the best remedy. People need to see how HOAs are mistreating vulnerable residents. I'll ask him. That evening, Jake gave his answer. If it can help someone else avoid what we've gone through, yeah, I'll do it. Within 2 days of the article's release, it was everywhere. Disabled veteran faces ramp removal in Ada battle, screamed across the Washington Post front page with a powerful image of Jake sitting beside the handcrafted ramp he built. The digital version spread like wildfire across the internet. Maya's story included direct quotes from the audio files and documented Karen's deliberate campaign against disabled homeowners. The backlash was instant and fierce. The local veterans group rallied behind Jake. Disability rights activists organized pickets outside the HOA office. Legal watchdogs started monitoring meetings. News outlets from CNN to Fox picked up the story. Karen quickly retained high-priced legal counsel, an attorney named Richard Morrison, and tried desperately to steer the narrative back in her favor. She gave a shaky interview to Channel 7, claiming the HOA was under siege from uninformed outsiders who don't grasp the intricacies of neighborhood governance. This isn't about prejudice, she said, her voice tight with nerves. We're simply applying fair architectural rules that protect everyone's financial interests. But Mrs. Whitlock, the reporter countered, you were recorded calling Mr. Ellison pathetic. That comment was misunderstood. I was venting frustration with legal hurdles, not insulting anyone personally. You also stated you didn't want the neighborhood turning into an assisted living complex. I was referring to maintaining the community's character, not targeting people with disabilities. What about the quote where you said you're not running a charity for cripples? Karen flushed crimson. That remark was taken out of context. I was talking about fiscal accountability, not making offensive remarks. You also discussed ways to get disabled residents to self-select out of the neighborhood. I was referring to standard enforcement measures that apply equally to all residents. But the damage was done. Social media was unforgiving. The hashtag #JakesRamp trended for 3 days straight. Karen's personal details were leaked, and she was flooded with furious messages. The threats got so intense, she had to hire bodyguards. Protesters camped outside her home. Local stores refused her service. Ellie's lawsuit was airtight, backed by Mr. Bennett's covert recordings and Karen's own incriminating documents. The evidence wasn't just compelling, it was overwhelming. Within a week, the Department of Justice launched an official probe. Federal investigators raided the HOA headquarters and Karen's residence, seizing electronics, financial logs, and internal correspondence. 2 weeks later, the courtroom was standing room only. Rows of veterans wore their badges. Activists held banners that read, "Accessibility is a right," and "End HOA abuse." National reporters filled every available seat. Karen showed up with her legal team looking rattled but oddly defiant, as though she still believed procedural loopholes might save her. Judge Williams, a former service member himself, took in the evidence with calm precision. Karen's lawyer, Morrison, argued that the HOA simply applied uniform design standards to all homes. Ellie stood and answered with surgical clarity. "Your Honor, the HOA deliberately targeted mobility devices while greenlighting fountains, gazebos, and other upgrades for residents without disabilities. That's a textbook case of selective enforcement based on disability." She showed photo after photo, upgrades in Red Maple Commons that never required the emergency design review forced on Jake's accessibility ramp. "The Hendersons installed a decorative fountain without permission," Ellie noted. "The Bradleys added a pergola. The Chens put in a trellis. None were reviewed. But my client's wheelchair ramp, essential medical infrastructure, was flagged for emergency removal?" Morrison tried a new tactic. "Your Honor, the ramp raises valid safety issues. Emergency vehicles might struggle with access." Ellie was ready. "The ramp is 3 feet wide. Fire engines are 8 feet wide. I have a written statement from Chief Martinez who says there are 0 access concerns and that Jake's ramp is an exemplary design." She added, "Meanwhile, the HOA approved a 6-foot-wide ornamental bridge over a drainage ditch at the Henderson property. No safety review at all. If access was the concern, that would be the greater risk." Then the recordings played, and the courtroom held its breath. Karen's voice rang through the speakers. "Jake Ellison is pathetic, and his gear makes the neighborhood feel like a care home." Then, "We need to make life so uncomfortable that they move to a more appropriate place." Then, "This is about demographic control. We don't want Red Maple Commons becoming a senior facility." And finally, "I'm not running a charity for cripples. This is a high-end community, and we need to keep it high-end." Gasps echoed through the courtroom. Some people got up and walked out. Judge Williams's expression darkened with every sentence. "Mrs. Whitlock, do you stand behind these recorded statements?" Karen's attorney frantically whispered to her, but she ignored him. "Your Honor," she said, "I was protecting the property value of every resident here." "By calling a disabled veteran pathetic?" the judge asked, his tone hardening. "By enforcing guidelines that safeguard the property value of hundreds of families. Context is everything, Your Honor." "Mrs. Whitlock, you called disabled residents cripples and claimed you weren't running a charity for them. What sort of context justifies those remarks?" "I was venting frustration over the legal complications, not making personal attacks on anyone's dignity. You also said your goal was demographic control to stop the community from becoming like an assisted living center. What did you mean by that?" Karen's face flushed with a mix of rage and humiliation. "I meant preserving a residential identity that protects long-term investments." "By singling out disabled homeowners?" "By applying the rules uniformly to all, regardless of their personal challenges." "Mrs. Whitlock, the recordings reveal you spoke openly about methods for pushing out disabled families. You even stated that you've successfully forced out 3 of them. That's not neutrality. That's deliberate systemic exclusion," Karen snapped. "Your Honor, if we allow one ramp and wheelchair setup to bypass the approval process, what's next? Hospital beds in the yard? Oxygen machines all over driveways? Medical vans parked out front around the clock?" A collective gasp rippled through the courtroom. Even Morrison dropped his head into his hands. He knew it was over. "Mrs. Whitlock," Judge Williams said sharply, his patience clearly wearing thin, "are you actually suggesting that accessible homes lead to hospital beds on lawns? I'm saying that ignoring rules opens the door to damaging precedents that alter the fabric of the neighborhood and hurt everyone's home equity." "You mean targeting war veterans who require mobility devices?" "I mean preserving standards that protect the investments of hundreds of homeowners. And the families you bragged about driving out. Was that protection too? I upheld the community's guidelines. Those families chose not to follow them. Guidelines that specifically target medical accessibility? Rules that maintain the community's identity for the benefit of all. Judge Williams didn't even call for a break. The court finds that the HOA has engaged in widespread, deliberate, and well-documented discrimination against individuals with disabilities, violating federal housing protections. I am issuing immediate injunctive orders to safeguard Mr. Ellison's ramp and to guarantee full, reasonable accessibility modifications going forward. In addition, I am requiring the HOA to release a formal apology in the Washington Post, pay $150,000 in compensatory damages to the Ellison family, and I'm ordering Mrs. Whitlock to personally pay $75,000 in punitive penalties for her particularly reprehensible conduct. I'm also mandating mandatory sensitivity and ADA compliance training for all current board members and placing this HOA under federal monitoring for accommodation policies for a period of 5 years. The veterans in the gallery erupted in applause. Karen sat frozen, stunned, her defeat sinking in like concrete. But Judge Williams wasn't done. Mrs. Whitlock, I am also forwarding this case to the Department of Justice for possible federal prosecution under civil rights law. Your ongoing actions toward disabled residents may constitute a federal crime. Karen's voice was barely audible. Criminal prosecution? Yes. Conspiring to violate civil rights under the guise of legal authority is a felony offense, Mrs. Whitlock, and it carries the risk of prison time. The bigger blow came 3 days later. Facing massive public outrage and legal consequences, the HOA board called an emergency session. In a unanimous vote, they stripped Karen Whitlock of her presidency and permanently banned her from ever serving in any HOA role again. The backlash was fierce. Each board member took the floor to condemn her behavior. I can't believe I worked alongside someone who deliberately went after disabled veterans, said Thompson, his voice trembling. Karen, what you've done is despicable. I never imagined such calculated cruelty and control, added Williams. You've turned neighborhood leadership into a campaign of persecution. You've dragged this whole community through the mud, said the vice president. Your behavior has made us a national example of everything wrong with HOA power. Karen's final speech was dripping with defiance. You're spineless. I was the only one trying to protect this neighborhood's quality and value. You've all caved to political correctness and media hysteria. Political correctness, Thompson shouted, getting to his feet. Karen, you called disabled residents pathetic and cripples. I was venting in what I assumed were private conversations during board sessions. Private venting? You orchestrated an entire plan to evict people with disabilities. I enforced rules designed to protect the value of this neighborhood. You broke federal law and betrayed basic human decency. I defended the assets of hundreds of homeowners. Williams slammed the table with his hand. Home values don't excuse the persecution of disabled veterans. Everything I did was within the limits of my role as HOA president. Your authority doesn't include trampling on civil rights. My authority includes enforcing the covenants we all signed. And those covenants do not supersede the Americans with Disabilities Act. Karen stood, face red and shaking. Fine, take me out. But when home values collapse because we've become a haven for every disabled person demanding special treatment, remember, I tried to stop it. The room erupted in fury. Special treatment? Shouted Mrs. Patterson. Basic access isn't special treatment. You're talking about veterans who sacrificed for this country, Tom Bradley bellowed. Karen snatched her papers and stormed toward the door. You'll regret this when Red Maple Commons becomes the textbook case of how diversity ruined a neighborhood. No, Thompson called after her. The only textbook case here is how one woman's bigotry tarnished an entire community. Jake's ramp remained untouched, a powerful and dignified symbol of justice, now protected by law and embraced by the very neighbors who once stood silent. But the legal battle wasn't over yet. The DOJ's investigation ramped up. Federal agents interviewed every family that had been pushed out during Karen's reign as president, and what they found was even uglier than we imagined. Karen had been carrying out a calculated campaign of bias for more than 5 years. Her targets included not just disabled individuals, but elderly residents using medical devices, single mothers with disabled children, and immigrants with limited English. Worse, they discovered financial corruption as well. Karen had been inflating HOA fines and skimming the overages. She'd fabricated vendors and submitted phony invoices for inflated service costs. In total, she had embezzled more than $50,000 from HOA funds, while claiming to defend the community's interests. 3 months after the civil ruling, federal prosecutors formally charged Karen Whitlock with multiple crimes: conspiring to violate civil rights, discriminatory housing practices, mail and wire fraud, and embezzlement. The criminal proceedings included gut-wrenching testimony from multiple victims. Maria Santos broke down in tears as she recounted how Karen had made her aging father feel like a nuisance to the neighborhood before he passed away. David Kim told the court that Karen repeatedly filed noise violations whenever his autistic son had therapy at home, ultimately driving them to relocate. Jake took the stand for 2 full hours, speaking openly about the emotional damage he endured. "She stripped away my dignity, not just as a person with a disability, but as someone who served this country. I started to believe maybe I really did ruin the view." Ellie appeared as an expert witness. This wasn't isolated or accidental. It was calculated exclusion, a deliberate strategy to push disabled individuals out of the neighborhood. It was targeted discrimination masquerading as regulation. Karen, however, displayed no guilt or regret during her testimony. "I acted to protect the values and appearance of this community. That was my responsibility." When the prosecution played the recording of her saying she wanted disabled residents to understand they don't belong, she dismissed it coldly as taken out of context. The jury returned their verdict in under 3 hours. Guilty on every count: conspiracy to violate civil rights, unlawful housing practices, fraud through postal services, digital fraud, and misappropriation of community funds. Judge Morrison handed down the sentence: 4 years in a federal correctional facility and $225,000 in combined restitution and fines. Karen's final words to the court were laced with bitterness and blame. "This case will set a dangerous precedent. Now any disabled person can weaponize the law against HOAs. This is how you destroy property values, by giving in to political correctness." Even as she was led away to begin her prison term, Karen still saw herself not as the perpetrator, but as the victim,